Evening. My name is Stephen Rapundelow. I'm head of Mish Bio. Thank you for coming tonight. We've got a really exciting program for you. But before we get into that, just a couple of quick announcements and some thank yous. First off, I'd like to thank the sponsors of BioArbor, and that being the University of Michigan Medical School Business Development Group, and of course Brinks Hofer. Without them, this event wouldn't be happening. So thank you to Eric and Connie and others in your respective groups. Also, thanks to Spark and staff and my staff at Mish Bio for all the hard work that they put in to actually get this thing put on every month. Two announcements. First and foremost, on your chairs are the registration brochures for our upcoming 2011 Mish Bio Expo and Conference. We have, I think, a phenomenal program laid out for you over the 2 days. We've just gone ahead and listed the speakers. You can find those all online. We've got some superb people coming in from all over the country, and I'm sure you'll find that the programs are going to be very exciting. So I would encourage you to register. If you haven't been to Grand Rapids recently and seen the expansion that's occurred in terms of the life sciences there, you really need to get up there during the expo and see it. One of the components we have, of course, is facility tours. We had our expo there in 2006, and the difference in 5 years is absolutely phenomenal. And I think you'd be missing out if you don't get up there and partake in that. The second announcement I'd like to make is to put a plug in for one of our preferred providers, G2G Consulting. I don't know how many of you know Liz Powell is there in the back. Stand up, Liz. Liz, what I like to refer to, so Liz is from G2G Consulting based in Washington and in Cleveland. I like to refer to her as what BBC is to SBIR, Liz is to alternative funding. Back in the old days, that was called appropriations, things like that. But she works with many life science companies. She works with many life science incubators and such regionally, actually across the country. And what happens is she comes in every month, the day of BioArbor, spends a half day in our offices, and Mish Bio members are welcome to sign up and have a chat with her if they have some thought or interest in trying to find dollars in some creative ways that the U.S. federal government might have. Department of Defense, you name it. There's actually a lot of pots of money, and you might be surprised. So anyways, Liz Powell from G2G. Okay, so let's start the program. Really pleased tonight to have all these speakers, especially those who came from out of town. I'm going to introduce to you Robin Razor, who's the Director of Licensing at the University of Michigan, Tech Transfer Office. In addition, she is, are you President or President-elect? President of the Association of University Technology Managers, otherwise known as AUTM, who is a phenomenal group who was participated in this whole topic as it was being debated over the last 5 years on Capitol Hill. So, Robin?
And thank you to all of you for coming here. I believe we're still under a rain delay. If you see me start motioning, that means they've started playing again. If you don't know what I'm talking about, don't bother. So for some of us, and actually probably more with my autumn hat on, a number of us have been through patent reform for longer than we'd like to admit, and some of us have road marks on the back of our back from this. But now that we have it, there's so much misinformation and information that we were hoping that tonight we've got a really nice panel to kind of give you an opportunity to ask questions, to hear a little bit about really what this bill means, and also try to help you understand if there's any changes in strategy or the way you're doing your business or the way you're handling, because there's so much out there about microentity fees, prior user rights, grace periods, things like that. So I think hopefully this will be an opportunity for you to hear from the three different sort of sides of the house about what patent reform really means to you specifically. What I'm going to do is kind of shortly introduce all of the the panelists so you kind of know who's talking. And I will speak for the universities with my autumn hat again. This is not a universally agreed upon bill. Like all bills out of the legislature, not everybody agrees to this, and we have many of our members are adamantly opposed and very worried about this bill. So we may get a little bit of information about that. So our first speaker is Hans Sauer from Bio. I've actually spent some time with Hans on some of these issues. He's currently Deputy General Counsel for IP at Bio. He's worked on the legislation for at least 5 years, as long as he can remember. Before he was at Bio, he joined Bio in 2006, and before then he was Chief Patent Counsel for MGI Pharma, who's a mid-sized biotech company in Minnesota. Before that, he was patent counsel at Guilford Pharmaceuticals in Baltimore. Some of you may have heard of them. And before that, a research scientist working on age-related neurological disorders. My favorite part is he still does some work teaching law school at Georgetown, where, I quote, he currently poisons young minds as an adjunct professor. Our second speaker, and Hans will talk a little bit about kind of the process of getting this legislation, and then down the road a little bit about what it means to Bio members. Our second speaker is Eris Sosenko, who is currently a shareholder in the firm of Brinkshofer, Gilson, and Leon. He gave me phonetics, and I haven't seen phonetics since I was in elementary school, so we had a lot of discussion at the office what phonetics meant. He has 22 years of experience in patent and trademark law, primarily in procurement, opinion, and licensing areas. Eric is currently serving as the chair of the firm's Patent Reform Committee and has recently given presentations on patent reform as far away as Japan. He's also currently serving as the Secretary, Treasurer, and Council member of the Intellectual Property Law Section of the State Bar of Michigan. And last but not least is Rick Brandon, who we're very fortunate at the University of Michigan is in our Office of General Counsel. But for those of you who are familiar with the University of Michigan, we're very fortunate that we have general counsel lawyers embedded within our office, so physically within our office, that help us day in, day out with licensing and litigation issues. And whether he likes it or not, his office is right next to mine, so I get all this great advice all the time. And prior to coming to the university in 2000, Rick was a partner in a patent firm in Chicago. And he also has followed patent reform very closely because really we're dependent on Rick to kind of help us with determining if we need to change our patent strategy as a university as well. So let's open it up. What we'd like to do is have sort of short presentations by our speakers and then really open it up to the audience such that you can ask questions and have a dialogue because I'm afraid of all the misinformation and information that you've already heard on patent reform. So let's start with Hans. Are you going to just sit there and do it? Oh, okay. Then I can sit here and watch.
I got a microphone for that purpose.
There you go.
Also.
Okay. But do you need this? No, you don't need
No,
this.
I don't have slides.
Okay.
And I will try to keep it a bit short. I was asked to lead off a bit with an overview, or a short narrative, if you will, of how we got where we got. How did we come to the point where we now have this bill? How did this bill evolve? And what could it have been? With respect to what it turned out to be. Bio, I think, has a long history of being very interested in IP matters. And part of our narrative on Capitol Hill, and whenever we go out and sell the concept of intellectual property, is the narrative of how important patents and intellectual property rights are in our industry, particularly for company formation, for access to capital, and what a unique role they play in the very long product development cycles that the industry must labor under, the large investments that are needed, and what role they play in protecting products that are frankly very long-lived once they enter the marketplace. It's a very different narrative from the high-tech industry, which, in our time when we were debating patent reform, was equally up on Capitol Hill, and they were giving a very different story about how the patent system operates for them, what its flaws are, where the problems are in the high-tech industry that necessitate patent reform. Patent reform, when it started in earnest in Congress, I would put it in about 2005, the early 109th Congress. The demandeurs of patent reform were really coming from the high-tech sector. It was big, well-known flagship companies that we all know, high-tech companies, very innovative companies. It was a group of big financial services institutions. And they went to Capitol Hill and said, look, there are all kinds of systemic problems with intellectual property rights in our very innovation-driven industry, the high-tech industry, that require us to make some reforms to the patent system. And these reforms they were asking for relate to, for example, the way intellectual property rights are valuated, especially in the context of litigation. What does it cost to infringe a patent? How do we calculate proper compensation if a patent is infringed? Other things that were being asked for were alternative proceedings, alternative to district court litigation, to review the validity of patents that have already been issued. And the story was that if you're a high-tech company and you put out a new product, which may be covered by thousands of patents, right? Smartphones, laptops, computers, telecommunications devices are very complex. They aggregate a lot of technology. So it's no surprise that the risk of infringing somebody's patent, if you deal with aggregated products, is very large, right? So high-tech companies explain that what they often find is that the relative value of an infringed patent, the relative value to the product as a whole is very small, and they end up paying larger damages in patent litigation than they feel is the economic worth of the invention that they allegedly infringed. Right? So there was a lot of that narrative coming from the high-tech sector that dominated the debate and that resulted in patent reform bills in earlier Congresses that contained very harmful provisions, we thought, for biotechnology and for the life sciences that are today no longer in that bill. And just to give you a flavor of the kinds of things that were in those bills. A recodification of patent damages. Again, so patent damages is what it costs to infringe a patent and how you calculate a reasonable royalty once you've infringed a patent. Today, when that happens, and a patent is infringed, and the judge says, yes, the patent is infringed, and the patent is valid, so this case is almost over. We now only have to talk about what it costs to infringe that, to make the patent owner whole. In order to do that, judges sit down with the parties and they say, well, what would you have agreed on as a reasonable royalty? If there hadn't been any infringement, if you had sat down at the time the infringement began, and you had negotiated a reasonable royalty, what would that have looked like? How would that have been calculated? What percentage would you have agreed to reasonably? Right? So it's a very flexible, market-based, multifactorial approach by which you determine how to license an invention, how to set a royalty rate, and in the same context, if a patent were ever infringed, how you calculate damages for infringement. It's the same process. That's what happens today. The high-tech companies said, no, we need something hardwired in law. We need to recodify this, and we must spell out a few particular factors that were all geared towards basically squeezing the royalty that would be calculated after patent infringement as a compensation for infringement. Members of Congress at the time when they were looking at these proposals that were coming from the high-tech industry said, yeah, we can probably do that. That all seems quite reasonable to us. And they didn't quite understand and didn't quite believe that other industries like the life sciences industry would have a very big stake in that kind of debate. Because after all, life sciences companies, while they litigate patents, biotech companies rarely litigate over damages. There's not often a question about how much money does it cost to infringe. The litigation is over, hey, you're about to enter my marketplace. If you do so, my sales will erode irretrievably, and I'm out of business. Right? So it's the injunction. It's about stopping people from infringement that really matters in life sciences and pharmaceutical or biotech patent litigation. It's not so much about how much money will it cost to make me whole. In biotech, there's usually not enough money to make somebody whole once a patent has been infringed and once an infringing product has been launched into the marketplace. Right? So with that, going to Congress and being up against high-tech companies who say this is a uniquely high-tech problem. how much does it cost to infringe. Biotech and the life sciences don't have that kind of problem. So why don't you give us this, and you give the biotech guys and the life sciences guys something else, like inequitable conduct reform. Right? That was the proposition that was on Capitol Hill in 2007, 2008. And that, I think, made it difficult for the life sciences in the beginning to react to very harmful bills that would have lowered across the board the value of intellectual property, that would have squeezed the value of patents in the licensing marketplace outside of the context of litigation, that would have created wide open patent challenge proceedings in the patent office where any patent could have been challenged on any ground under a relatively low standard of proof, repeatedly if necessary throughout its lifetime. Right? Those were other ideas that were in patent reform, the so-called second window post-grant opposition, which is not now in the patent reform law, for good reason. Right? There were other things in the law that we fought, and maybe we can go back to that afterwards. I think I want to leave you with this notion that, yes, to the extent this bill passed now, to the extent we can say we've worked towards this bill for 6 years, it's also a bill that we have fought for 6 years. And the work product, while it is the best we've seen in 6 years, just like Robin said, is not a perfect work product. I don't think, there will ever be agreement that this is the ideal bill that we would have procured if we'd had our way. We didn't get all we wanted. Bio did not. Nobody did. But it is, at the end of the day, from what I'm hearing from Bio's members, a decent work product that, on balance, improves the system and makes it more predictable. We can talk about why we think that is and where the benefits of the law are. As we go forward, like the final thing I really quickly want to say is, well, maybe nothing. Maybe we'll do that when we talk about the new first-to-file system, because that is really such an interesting discussion in and of itself. That amazingly, while it's the biggest change in the law, when you look at it, it's the biggest legal change that has been subject to very little discussion during the last 6 years. People were fighting over how to litigate patents and what it will cost to infringe them. People were almost not interested in the new prior art regime or what will it mean to go to a first inventor to file system. But we can talk about why that might be. But, so for now, this is a brief overview of how we got there. And now let's see where we actually are and what it might mean.
So, and down the road we'll also talk, I think the other big controversy is funding for the Patent Office, and that ended up being a lot of discussion as well toward the end, and we can talk about that later. So Eric is going to spend a little bit of time talking to us about actually some of the things that are in the bill. Do you want to get up and move? Or?
Yeah, I do want to walk around. Can everybody hear me? Is this mic on? It's kind of tough to hear when, oh, there, I can hear it now. What I wanted to do today was just talk a little bit about what actually is in the bill, go over some of the topics that are brought up to me, what are the main discussion points that we're hearing out there. And so I'm going to be a little bit more specific about individual items in the bill, not going to go into any one in great detail. There were 37 sections in this bill. The bill itself was over 100 pages long. Was merged with the bill out of the Senate, not merged with the bill out of the Senate, but the Senate ended up adopting what the House did. So if you've ever read legislation, it's not easy to read. When they amend the laws that are out there, it's insert this here, take that out there, and then sort your way through it and try to figure it out. So what I did was just a little bit more on the historical context. The last major enactment of patent reform was back in 1952. So it's been 60 years since we've had significant reform. And this bill, in and of itself, has been, like Hans said, battled for the last 6 years at least. The House has passed it a couple times, different versions of it. The Senate has never wanted to pick it up and even take it to a debate or anything. They finally went through with it, and then it was signed into law a little less than a month ago. So what I've got here, out of those 37 sections, some of those sections deal with reporting functions that the Patent Office is now being charged with doing. For example, a couple interesting things. there's actually a section where the Patent Office is going to look at doing pro bono for intellectual property. So it'd be very interesting to see what they come out with on that front. There's another section about international protection. A report due, I think it's in January on that. And so the interesting thing there is whether or not there should actually be grants and funding for international protection for small companies and everything. So it'd be very interesting to see what they come up with that. But outside of those reporting functions, what I have here is about 15 different bullet points that go to the issues that are more substantive and that I'm hearing about. Hans mentioned the first one that comes up is probably the most drastic change in the system, the first inventor to file. One of the things I always hear is that we're going to a first-to-file system. I always like to say we're not going to a first-to-file system. It's a first inventor-to-file system. So it's very important to make clear that you still have to be an inventor to get the patent. You can't just learn of it from somebody else, go in and file, and get the patent. So the idea that there's going to be a lot of theft and it's just that pure race to the Patent Office door is not quite there. And to help out with that, we have a proceeding that's called a derivation proceeding. So if it ever does get to that situation, you can go in and with the administrative proceeding, seek to get that patent back. On the first to file as well, we still are going to have a grace period that's involved with this, the 1-year grace period. That brings up a lot of interesting discussions that Hans was alluding to and how that will come into effect. But that grace period relates only to the inventor's own disclosures, so that's what starts everything rolling there. A couple things from a mechanic standpoint once you get into the patent process. The oaths and declarations, they're still required. The inventor has to sign an oath that they are a true inventor. They're making some provisions so that companies will be a little bit easier going forward. You're now allowed to put that into an assignment document. Before they had to be separate documents. You can put them together now. Now the company, where there is that obligation to assign, can step in and proceed as the applicant under the new law. That's going to make it a little bit easier, particularly in a situation where an inventor is no longer with you and might be a little bit hostile to you for whatever reasons. So if you have that obligation in there where you can document that, it's going to make it a little bit easier for you down the road. The best mode requirement, I don't know really what I ought to say to this, and the best thing I could say is it's voting present. The requirement is still in there under U.S. law. You have to describe the best mode to practice the patent, the invention. Under foreign law, typically everywhere there's no such requirement. So what they did as a compromise, the U.S. had that requirement. They left the requirement in the law, but they said that requirement cannot be used against you in litigation to invalidate your patent if you do not comply with it. So it's a requirement in patent law that has no teeth, and we'll have to see where that goes. I think it puts a lot of attorneys in an interesting situation where there could be a lot of allegations of ethical violations that you knew that you should have had this in there and didn't put it in there. So it's actually got attorneys wondering how we come into play with that. So, but if you think about it from the only place it really can come up now is in the patent prosecution situation. So the examiners can raise it. In my 22 years, I've never had an examiner raise a best mode question regarding patentability. So it's not going to pop up there. So Hans, you were patent counsel as well. You probably never got into that from an examiner anyway.
No, but we had to think about it inside the company, of course, especially when we filed continuing applications. It was always, what else have we learned about the invention? Do we now have a better way? Maybe do we have to put that in? And there was always this pressure of, I'm not sure we want to put that in. It's going to become public. And I'm like, exactly. It has to.
So it'll be very interesting to see where that comes out. And that's going to be a battle somewhere down the road, just not exactly sure where. There are a couple of provisions regarding prior art submissions, regarding pre-issuance and post-issuance. Pre-issuance, there's some timelines where if you're aware of art and you're aware of a pending application, you can get that submitted with a concise explanation of how it applies to the claims in that patent application and force the examiner to consider it. Post-issuance, you will be able to submit prior art, have it basically become official part of the record, and if somebody does get involved in one of these post-grant proceedings or these post-issuance proceedings that I'll mention here in a second, they will come into play and the examiner will be allowed to take a look at those. Interesting thing on the post-issuance proceeding, prior art submissions, is it doesn't have to be just prior art as we know it. It can be statements and admissions by the patent owner themselves regarding their patents. So I think you'll see some of that coming into play where maybe in another litigation or in another proceeding, an owner said one thing about their patent and that it comes back to haunt them, that it gets submitted in another proceeding and used against them. So not just prior art from the standpoint other patents, other printed publications, but statements. Priority examination, there's a couple of provisions that they've added for that. One is what I call pay to play. There is what's called track one priority examination, whereas if you're willing to put out enough money for it, they will advance you ahead of everybody else in the queue. For small entities, that fee was set at $2,400, so it's not exactly cheap. For a large entity, it's twice that, $4,800. So, but it is there if somebody wants it. We'll see how that comes out. I think it's pretty steep, so I think it's going to keep a few of them down, except for some of the big companies. The other one in there for priority examination is kind of open-ended. It hasn't been defined. We'll see how the regulations define it. But if a technology relates to something relative to the national economy or the national competitiveness, then the Patent Office can deem that an important technology and give it priority examination. The Act does not say what kind of technologies those will be, so we'll see where that one comes out. Virtual patent marking to recover damages in litigation. The best way to recover it is to mark all your products. If you don't, then it's from a notice standpoint of infringement. They're allowing, that's always a problem because if you're putting packaging out and you got a physical product putting packaging out, put the package out before you get the patent number, there's no patent number on it, then it comes out, you put a patent number on it, you got to change all your packaging, got a second patent, you got to change it again, patent expires, you got to take it off, so there's a lot of hassle about doing that. So a lot of people just fail to mark as efficiently as they can. Virtual patent marking, in my opinion, just makes sense now. Allows you to put patented on the product, refer to a website, put your patent numbers on the website, take them on and off as it comes. So it's going to be a lot easier to mark your products via that. One caveat there, it does have to be available to the public and freely accessible, so you can't bury it somewhere and make people pay to see what you got. We talked briefly about funding. I like to say the PTO is almost fully funded. A problem with the PTO is that you may or may not know it, even though they collect fees, they do not get the benefit of those fees. There's an appropriations that's given to the Patent Office every year. That's the money they have to spend. If they collect excess fees over that, it goes into the general fund and is spent however Congress wants to spend it. Just saw a report this week that said for the past fiscal year, 2011, $200 million in fees were diverted from the Patent Office. So when we talk about backlog and we talk about not enough examiners and everything else, you can see $200 million would go pretty good ways in trying to help us alleviate those. So the new Act basically says that any monies that are collected above and beyond the appropriations will go into what's known as a reserve fund. That fund is held just for use by the Patent Office, but it still is. Is that my phone, or is that everybody's got the same phones? So, but that money still subject to appropriations. So even though it's put in the reserve fund, Congress will have to authorize the availability to spend it. So, but at least it's being put specially into its own fund. Satellite offices. I'm sure most people here have heard about satellite offices since Detroit was selected for the first one. So we do have a satellite office that's going to be coming here. The new Act mandates 3 total within 3 years, subject to funding availability. So I think we're going to see a couple more offices pop up. Does have to be some geographic diversity in that. I would expect that we're going to see one on the West Coast somewhere and probably see one down south, maybe down in Texas or somewhere like that. Other things we talked about post-issuance, this really goes to contesting or strengthening patents, being able to have an alternative to litigation to invalidate patents if you find something out you think shouldn't be issued. First thing I want to say, one that's not talked about right now, we're hearing a lot about the latter two, post-grant review and inter-parties review. Not hearing much about ex parte reexamination, which does currently exist now, still alive. I just want to make sure everybody knows that. That's a situation where you basically file a petition at the Patent Office with some art and your grounds as to why this patent's invalid for various reasons, and then you back away from the proceeding, let the Patent Office handle, and they go into and they re-examine it if they go down that proceeding. Post-grant review is the broadest of the inter-parties review, where you have two sides involved, the patentee and then the petitioner themselves. That's basically any grounds that they could have invalidated the patent when it was gone through prosecution, whether it's novelty or obviousness, or whether it's the written enablement. The one excluded there is best mode that we talked about, so you cannot use that ground to invalidate it. Once a patent issues, you'll have 9 months to submit this, or somebody will have 9 months to submit it against your patents. Once you get past that 9-month period, if post-grant review has not been implemented, then you enter into what is inter-parties review. The grounds that you can invalidate a patent at that point is more narrow. It does have to be printed patents or printed publications, but it does go for the length of time of the patent. So a little broader at first, but a more narrow time to get involved. A couple things to remember: if you do get involved in these estoppel principles, meaning if you raise an argument or could have raised an argument, that's your shot at it. You're not going to be able to raise in litigation down the road if you ever were to get into subsequent litigation as well. A couple interesting things there, if you think about it, because post-grant review is very broad on the grounds you could have raised or challenged it, your estoppel is going to be a lot larger if you go under that ground. So we think that a lot of this is really going to go in inter-parties, save other grounds for litigation in case you need it, almost give you a couple bites of going at it. Just these are the last three things I wanted to mention. Litigation, been various changes. One of the ones that we recently saw a lot of was multi-party litigation. You see a lawsuit filed, and you basically be going after an entire industry. The troll situation that many of you are familiar with, they've made changes to that. It has to be a common transaction to bring in multiple defendants. So we saw Russia filings just before the bill was signed and just before enactment of it. Those dropped off the day after, so we're starting to see, again, 1-2 defendants, not 24 defendants or anything like that. Prior user rights, that's a defense to infringement. This was expanded under the new law previously. What the law was, that if you were practicing a method that was in a method patent and you were doing that prior to the issuance of that patent, you had a defense in certain instances that you could use if you were accused of infringement, and that would get you out of that. This expanded it not only to method patents but to all patents. So your product patents and your machine patents or device patents, everything else, those are going to come into this. They also expanded who could assert it. It can be the persons who directed another to perform the method, not just the person who performed the method. So this is going to be a little bit broader. I said except against the U because they got their own exemption in there that you can't raise this defense if the university comes after you. So.
Although, I think there's still a question about when we license. What happens if we have a licensee?
Yeah, that question's not in there.
Right.
You might not have it then, but there is that exception. So I just thought I'd put that in. Then the last one, advice of counsel. This relates to the subject of willfulness. In litigation situations, if you are determined to have willfully infringed a patent, the damages could be tripled. One of the ways that you would set up a defense to that line of argument is to get an opinion from your patent attorney that basically said, the patent attorney said, no, we looked at it. There's reasonable grounds to assume that you are not infringing and that you'd have that opinion. Those opinions are not cheap, and so people would sometimes really ponder whether they should spend the money to get it, and often spend it now. And then if you didn't get it, it was used kind of against you. You didn't get the opinion, therefore you didn't want to hear bad news. They've codified, it was a case law that had come down that dealt with this, and they codified that basically saying you cannot draw that inference. If somebody did not get the opinion of counsel, there's valid reasons to not get it. You can raise willfulness still, but you can't use that against them that they did not go out and get that opinion of counsel. So those are about the 15 biggest points that we're hearing people talk about or asking us questions. So they're all open for discussion here.
Thank you. So our next speaker is Rick Brandon, who will talk a little bit about what it means for universities, but I think also perhaps what it means for some of our small businesses and our licensees as well. Top of the first, no score. Oh, do you want to stand here? You're moving me, in other words. This is how we work all the time.
How's it going? So I'll be brief, and we can leave some time for questions. Like Robin said, I'm here to give a little perspective from the university side. maybe also a little bit sort of from the client side, although I'm a lawyer, I'm in-house, but I know the client all too well. And so I can bring a little bit of a different perspective. I've got some slides here that were really intended to be notes, but the nice folks here put them up on Eric's PowerPoint thing, and so I'm already committing trademark infringement. But so this first thing here is supposed to just show you that just a little bit visually that there was in the law there's some things for everybody, and I suppose that. And Hans can speak better than I can on it. I mean, I suppose biotech in general would have been okay just with the status quo, but there are some things that everybody, including biotech, got out of it. So, on the top of this thing, it shows there are 3 or 4 or 5 things here that show what the patentees got and then what the infringers got. One thing there was a worry when we went to first to file, and when we started messing around with things, there was a worry that we were going to eliminate the grace period. What we did was we had a compromise where we've kept the grace period for the acts of inventors, and that's, I don't know, from our perspective, that's maybe the single biggest worry that we would have had, is that somehow we would have been forced to file before inventors are able to get out there without us controlling them and get out there and make public disclosures. So we did retain that aspect in the Act. On the other hand, what we did give up as far as the patentee goes is we gave up what some might think of as a sort of a grace period for the disclosures of others, disclosures by third parties. It's not really so much a grace period, but the way our law played out, that lumped them all together, so there was it was a 1-year time period between a public disclosure and when that public disclosure became prior art. We've split it so that now you got the grace period for the acts of the inventors themselves, but not for acts of third parties generally. What patentees also got, and sometimes some of our colleagues at other universities have been talking as this has gone on, they've had some fear that we've damaged patents too much, but sometimes folks forget that what we have also done for patentees is eliminate much, if not all, of the secret prior art, secret activities as prior art. So somebody could have been inventing in their garage something similar to what a company was doing in a lab, and that invention made by the guy in his garage would be prior art against the company, even if nobody ever knew about it. And the particular problem with that is that in litigation, I mean, typically that only comes up in litigation later. So when you have all this prior art potentially lurking out there, you have lack of predictability, because these things often, not always, but often pop up in litigation. So that was one thing the patentees got. Infringers got a post-grant review. We were able to folks were able to negotiate out a sort of a second window that Hans referred to, but now we've got one additional mechanism in conjunction with some of the others that still exist for review of patents right after issuance, for 9 months after issuance. Patentees, on the other hand, got an estoppel effect of those. That's really pretty good, and I think, as Eric is saying, that's going to scare off some folks from going that route. A couple other things to toss out there that patentees got that Eric has already mentioned, but one is elimination of the best mode requirement, although there is definitely a watch out there that we don't really know how that's going to play out for a number of reasons. So we're going to have to sort of keep watching there. Another thing is supplemental examination, which is a brand new thing which patentees will be able to use to go back to the patent office once they have a patent and they've recognized that there are problems with it. And what this is sort of commonly thought of is as a way to cleanse what might allegedly have been inequitable conduct, which is something that can cause you to lose your patent. It causes your patent to be unenforceable if you haven't provided all the prior art to the patent office that you had in your hands, or described something incorrectly to the patent office. So that's a big plus for patentees. So, and then at the end, we're just showing, I'm just showing you that the biggest thing that we got that's already been mentioned, we got predictability, and hopefully we're going to get some speed and some solution on some of the funding problems for the patent office. So one of the things I was focusing on, because as a client and a patentee, and also hearing about some of the university discussion, we've had a lot of folks worrying about what does this grace period mean. And you're not going to be able to probably decipher exactly what this all is here, but the goal here is just to show that while we have lost some of the what might arguably have been a grace period, the public disclosures of third parties, we've kept most of what we need. We here, at least I feel it here in Michigan, when we do a lot of patent prosecution ourselves, we've retained in the grace period side of things what is essential. So so on the left side of this thing, what we're showing is what it used to be and what it is now. So one of the things that we used to have is a grace period for disclosures. I'm sorry, we don't have a grace period. We have disclosures that are greater than a year old by an inventor are prior art, right? That's sort of the basic. That's sort of the basic thing of a grace period. That was the way it was then. That's the way it is now. Another thing that we had in the prior law was that less than 1 year old of a disclosure by an inventor is not prior art. Okay, so that's just another sort of basic premise of the idea. That remains unchanged. We under the old law, disclosures that were more than a year prior to the filing date by an inventor, disclosures by others, are prior art, and that also has remained unchanged. Those older disclosures are going to be prior art. This is where we get into the little bit of a controversy, but disclosures that are less than a year old by third parties, by others, under the old law were not prior art, and that is changed in general, but not necessarily, but in general, because there's something kooky that happened. Those things will now be prior art, but as a university patentee, we feel that we've retained these other things that are important to us. And I mentioned the last point there that secret inventions will not be considered prior art. So that's the thing that the patentees got. So and then to get sort of the punchline of what universities and small companies might think of, and that's what they sort of asked me to mention. And I think overall my message is that while we hear lots of messages in the media that particularly by maybe some politicians that this is an act that's going to just be good for big companies, we just don't feel that that's the case. I mean, yeah, there are going to be some things where big companies will be advantaged. There'll be some cases where they'll be disadvantaged. A couple points to hit. Because we're no longer under a first-to-file system, I think if you look back historically, I've never done any research on it, I think one of the main reasons that we worry about lab notebooks being signed and dated were for reasons of patents. And that's something that I know here at Michigan we are generally pretty disappointed when we go to lab notebooks when we need them, when we've needed them to argue about invention dates. You no longer, at least for patent purposes, have to worry about that in the same way. Start talking about grace periods and that sort of stuff. Where everybody's worried, can small entities rush to the patent office with companies, and we feel we're sort of in between. We're big, but we're not. We're small, but we're not so small. We're big, we're so big. But we feel that we can, even into the academic environment, that we can react and get to the patent office as fast as we need to get to the patent office. Before the law changed, there were lots of reasons to get to the patent office and file a patent application as soon as you possibly can. And under the new law, it's the same thing. There's lots of reasons. I mean, they're just more stare you right in the face. There are more reasons to get to the patent office and file a patent application as soon as you can. Lots of bad things could have happened to you before under the old law if you didn't file soon. So we're not so worried about that. Post-grant review is something these guys have mentioned already. It's something that for small entities like us, we're sort of small, like I say, we're going to have to watch and see how this affects our practice, because it's going to be something new. Once you get an allowance from the patent office, you're not going to be able to to know that you're done spending money, basically, because third parties out there can come in and oppose your patent. And this is, by the way, something that's been going on for years and years overseas. Although ironically, Japan has gotten rid of their opposition procedure, but it's something that we'll have to keep our eyes on because it probably will initially increase our patent expenses. But again, the benefits of that are some increased predictability not only just merely because of the estoppel effect against a particular opposer, but also because once it's more prior art and more examination is undergone at the patent office, in general, that's going to give you more predictability of a patent that's going to be enforceable when it's in litigation. Another thing that we've heard a lot about are micro-entity fees that will apply to I think generally, although I haven't studied in detail, generally to individuals, but there is a sweetheart section in there for universities, and universities will be able to take advantage of these micro fees. However, patent office fees really they sort of pale in comparison to what Eric charges you to prosecute your application. So, yeah. So I mean, it's just your fees are in other things. Your fees are in making the inventions. Your fees are in paying the lawyers. Your fees are in doing other things. It's nice to have a micro entity fee that will save you another 25% on what the filing fees and the government fees would be, but it's not gonna save the world. So the last message there is is the main one. That the sky's not falling. Let's just see how it shakes out. So that's plenty for me.
Sort of the one thing that none of you guys mentioned, and as an advantage, although I've heard it as a disadvantage, is part of this was also to try to harmonize us with everybody else in the world. So the U.S. had a different system than everyone else in the world. Now, this is getting us much closer to being harmonized, and when we meet with WIPO, which is the World International Property Organization, there is some attempt to try and get them to develop a grace period, because when you talk to the Europeans and others, they would like to have something similar. So there is some talks amongst the organizations about trying to get a grace period for them. But this does get us closer, and let's face it, the vast majority of our technologies have applicability not only in the U.S., but elsewhere. And to have to deal with two different sets of patent rules has been kind of confusing over the years. So this was partly a good thing, and a lot of people, I think, do believe it's a good thing that we're moving more and more toward harmonization. We've got to understand how the patent rules are overseas. I think what I'd like to do is open this up for questions. We've got about 15 minutes for people to ask questions of the panel. I'd say just we've got a microphone back there, or it's small enough, just raise your hand and ask your question and to who you might want to ask it to. Well, that's the grace period, but again, it's only in the U.S. So a lot of this is education for faculty. So if they disclose, nothing has really changed. If they disclose, we still can't get a patent overseas. All that's done is it's given us, we have that grace period still in the U.S. It's changed a little bit, and Rick can jump in. But if you disclose without filing, we're only talking about a grace period in the U.S. So that we didn't harmonize across everywhere. Now, I don't know. It'll be a long time before we see that grace period. They're talking about it, but right now it's just in the U.S.
If a third party discloses? So if you disclose and then somebody reports what you disclosed, is that a third-party disclosure that counts as prior art?
We can let's do this in a dialogue.
All right.
So the way it might work. Hold on.
Go ahead.
The way it might work is that you make an invention. Say you're a small business, right? You invent something, interesting widget. You want to get investors to help you manufacture it or something. Or you're a faculty member and you want to present it at a scientific conference. But let's say you invent the widget and you're going to look for investment. And you go out and you got to tell people about it. Maybe at an investor conference. Maybe you have slides. Maybe it gets printed up in a brochure and so on. So that could at some point rise to the level of where you put a disclosure out there that's going to be accessible by others as well. Not just by the people who you were talking to, but it's going to be available to people outside the room, to people in your industry. Right? If it rises to that kind of level, then it's the kind of disclosure that's going to destroy your chance to get a patent overseas if you haven't already applied for one. In the U.S., that kind of disclosure is not going to ruin your chances to get a U.S. patent if you apply for the patent within 1 year. If somebody else hears about what you talked and discloses that and reports it, say, in a paper or wherever, that disclosure comes, if you can prove that it came from you, he really disclosed only what he heard from me, it's not going to work against you. In fact, it's going to ruin all his chances of getting a patent of his own on what he heard from you. So it operates basically, if you make a proper disclosure of your invention within 1 year, it works almost as if you had already applied for a patent in the U.S. And it destroys everybody else's chances of getting a patent on the same thing, even if they invent it independently after you disclosed it. And so it's really a very robust grace period, but the price for getting that is that you really have to put your invention out, in a rather assertive way where it's really accessible to others, where it's quite public. Not everybody is going to be comfortable with that. So the safe thing, tell me, would be perhaps to file a provisional patent application or.
So from a university's perspective, the question that I've had is there an advantage then to us? We file the provisional and then we tell our faculty, go out and, publish sooner rather than later, or is there no advantage?
Well, I think once you have the provisional filed, I don't know if there really is any advantage to publishing after that, because you've already put the stake in the ground, and that's going to count as your effective filing date around the world.
So the only advantage would be is if for some reason you thought you only wanted a U.S. patent.
That's exactly right. If you knew your only market was going to be in the U.S., that's a big debate right now. Said, well, did we just trump provisional applications by saying a disclosure is better for you? Because we could have the situation, like Hans said, where you have your public disclosure. You disclose it in sufficient detail that you basically disclosed everything there is to the invention. Somebody else never saw it, had no access to it. They're working on it at home, and they file their patent application after your disclosure. Your disclosure is going to be prior art to them. Their application is going to be knocked out, but you have your grace period still running. So there's kind of an equity principle there that once you have your grace period established, a subsequent filer can't cut that off from you. So you'll still be able to go, and their filing will be gone. Yours will be allowed to proceed even though you filed after them, but you disclosed before their filing.
So the law, essentially, I'm the voice of, nothing's changed, and nothing has changed here, really. If the law is convoluted the way it's written, but basically what it says is that once you make your public disclosure and you're going to rely upon your 1 year grace period, whatever anybody else does disclosing your invention, it don't matter. So, and that's what it was under the old law, for different reasons. But under the new law, you really are guaranteed for your own disclosure 1 year. And we could get into describing why the law is written in a convoluted way, but that's what it says.
A quick example of the one thing that has changed under the new law is the following. You apply for a patent. Here's my invention in the patent office. Patent examiner searches the prior art and he says, 4 months ago, somebody wrote a scientific publication on something that's kind of close to your invention. It makes your invention obvious. I'm not going to give you a patent on that.
Yeah, that happens a lot.
If that happens today, then you can go to the patent examiner and say, but I invented it before this guy published it. So whatever he does cannot make my invention obvious. We can remove this from consideration because I invented it before this publication came out. If it was within 1 year, before the date. Yeah.
The lab notebook is still important.
The lab note, under the new law, it's going to be less important. It's still going to matter if you ever have to prove the provenance of your invention, how you came about doing it. Not just dates, but kind of who had the idea, where did it come from? Because there might still be allegations by other people who say, you heard it from me, you tweaked it a little bit, now you're trying to pass it as your own invention. And there can always be disputes.
Right. You remember we mentioned briefly derivation actions. So the lab notebooks are still going to be important from that standpoint, being able to prove that you originally conceived it, you didn't derive it from somebody else. Maybe you're working in a field where you know your colleagues pretty well. You have an idea what they're working on. Maybe you don't disclose exactly, but you do have that idea. So having those lab notebooks are still going to help you out. The other thing I want to say is this doesn't kick in for 18 months, so don't anybody just go stop, doing your lab notebooks. We still have to play under those rules for another 18 months. So,
just a comment though on first to invent. It is exceedingly rare for a first inventor, second filer under our current system to ever get a patent. And I think the head of the PTO just recently gave the stat of in the past 7 years, only 25 times has a patent been issued on a first inventor, second filer. So while there's good and bad about eliminating. By eliminating the idea of swearing behind a reference.
Yeah, an interesting stat on that I saw recently was that the proceeding that you go under there is called an interference to see who's really the first to invent. Last year there were about 520,000 patent applications filed in the U.S. There were 52 interferences filed. So you can see that the number that came out is like he's alluding to is, and that's the ones that are filed. That's not who won them. That's just how many were filed. So just taking it back, there's never been a lot of them filed in any given year. So the concerns about it probably are a little bit more hype than they are actual.
Yeah, and plus when you do go into it, it costs you a couple $100,000. It typically, unless you already have the university side of it, unless you already have a licensee, we're sort of done from the beginning.
Have we thoroughly confused everybody?
While you're all thinking about questions, the new proceedings that we'll have in the Patent Office for challenging patents. Right now, we don't have a lot for that in the Patent Office. We have what's called re-examination proceedings. They're not cheap. Nothing's cheap that relates to patents, but they're kind of limited. But these new proceedings will be full-blown mini trials, if you will. They will be as expensive, I guess, as interferences. Those rare proceedings are now. Hundreds of thousands of dollars, we can assume. So how does everybody feel about the thought? A lot of you will have patents of your own, like you will be part of small businesses. How do you think about the prospect of possibly being dragged back into the patent office where somebody wants to attack your patent? And you'll have to put up a couple of $100,000 to defend your rights.
You're a public defender?
See, I think not for that. There's pro bono talk.
Yeah, I don't know if the pro bono. We'll see if the pro bono comes down on that or I have mixed feelings about it. In one sense, I think it's good because unless it starts down the road of it as an abusive practice, but I do think that there are some grounds to. I think the estoppel provisions, really will come into play to prevent that abuse. You really don't want to lose any argument because if you go through, let's just say you go through and you fight it and you weren't successful, so the patent owner wins, they're happy and everything, and yeah, they did end up spending money, but now that patent's going to be a heck of a lot stronger, especially against that party. So they're going to have those estoppel provisions that are just they're not going to be able to come at you from every single ground they could if you ever were to go after them for infringement down the road. So I think that's going to hold them back a little bit in check. Europe, I think, currently is running around 5%, which is still pretty high. A significant number, but that's what their opposition practice is going at in terms of how many issued patents undergo it. I don't know what the how many are narrowed or how many are invalidated. I don't have that statistic, but. So in that sense, I think as long as there's some checks on the abusive nature that anything could be abused, but if there's some checks on that, then I think it's good because in the long run it does give you a little bit more certainty, both from the standpoint, even if you're an outsider just sitting there, that the big names in your industry are going to be fighting patents that shouldn't be issued, that they think are going to come around, and so I think that can be good.
Very quickly in response to that. We're putting our hopes in the Patent Office because the Patent Office has the power to set the standard for the showing that must be made before they will start such a proceeding. Right? We're granting about 200,000 patents per year. So if
we have the European frequency of patent challenges. That would be 5% of 200,000. That's thousands of these proceedings every year. The patent office can't do those. And it's in their interest to do as few of these as possible, as many as they can manage. So they will set the bar very high, we think, for getting such a proceeding started. They have a lot of flexibility. They have new statutory language which they can fill with meaning. And so, we hope, that there will be relatively few frivolous challenges, that, to the contrary, the Patent Office will only permit proceedings to start on the most unambiguous cases, where really the patent just shouldn't have been granted. And in fact, if it's one of your patents, you're better off without it. It's that kind of thing.
And the other interesting thing is, we're talking like all of this is new, but there is inter-parties re-examination right now. That's being replaced by this inter-parties review. So we do have some form of this right now. We have not seen it. I thought it would actually be used more frequently than it is right now. And I don't even know if it's 1% down at the Patent Office. But it's out there right now in a similar form, not as extensive from the discovery aspect that you're going to have with the review that's coming out now. But there is something similar out there that just has not gotten everybody that excited. So.
The number is exceedingly low. I mean, it's been greater, I think, in the past couple of years. But it would scare me if there was 200,000 and it was 5%. And we'll just have to see. But I just can't believe that would be anywhere near that.
One other thing, there is a website that the Patent Office has that's literally for implementation, but I can't remember. It has the schedule. It has a lot of information on it. It's probably uspto.gov.
Yeah, if you go to uspto.gov and then search under AIA or IAI. No, I can always say it backwards. I keep forgetting. America Invents Act. So it's search under that. You'll find the implementation page. There are multiple pages under there with overviews and as much detail as you want to dig down into.
One or two last questions before we close up.
Small business, 5 to 10 people working. The guy makes a unique product that he manufactured and designed. He's kept it a trade secret. Now, under this new patent, or the new law, is there any still protection for a guy like that, or should he start looking at filing a patent for something like that?
Well, I don't think it really changes that. I mean, trade secret law still exists, and you always ran the risk if you kept things trade secret that somebody else would come out, disclose the invention, and the trade secret's gone. So once that gets out into the public domain, trade secrets are, they lose their value at that sense. So even if somebody else were to file on it, you might have had, if it was methodology, you might again have had some prior user rights or something like that. But from the standpoint, I don't think it's really changed much of that. So
it's on the prior user. In fact, like the law gives you a little bit of relief compared to what the law is currently. Under current law, what could happen to you if you were that company is that you use it in your own business, keep it a trade secret, somebody else invents it, gets a patent, and comes after you and shuts you down. And you go like, I've been using this for years. I invented it too. I just didn't apply for a patent. I used it in my own business. Under current patent law, that could be a real problem, and you might have to stop using your trade secret process if it's not just a business method. That's the only thing that the current law provides some protection for. The new law, expands, I think, the prior commercial trade secret use defense that you have. If somebody comes after you with a patent and you say, I've been using this in the secrecy of my own business for years, and it's been quite a while, then the patent can't be asserted against you. Now, you can't knock out his patent on the basis of that, but basically you'll be kind of immunized.
Well, of course, ironically, that was the big issue for a lot of universities.
For a lot of universities,
because the obverse is true. You get your patent, you license it, then you find somebody who's infringing, you try to make them pay, and they say, no, I've been using, So this was a lot of the issues with universities and some of the small businesses. So, for every person on this end that something's good, there's somebody on this end that it doesn't help them.
A lot of discussion around that was like patent law is supposed to encourage disclosure,
Right.
and not patent
Secrecy.
law is supposed to encourage trade secrecy. And so that, I think there was some tension.
And especially for
yeah.
the university community where, let's face it, we don't really keep secrets. That's not what we're supposed to do. And
Usually
so,
have the other problem.
Yeah. Did you? Nope. Well, I want to thank our esteemed panel and all of you for coming here. It's still 0-0, so you haven't missed anything. It's the beginning. It should be the beginning of the third here pretty soon. So there you go. Thank you so much for coming.